Lawyers have read it. What's the most jaw-dropping legal loophole that most people don't even know exists? Story 1. As a lawyer, I'm going to give a serious answer, which may not be super interesting to the layman, but is an example of a true loophole. In Australia, as in most developed countries, we have a set of laws designed to stop company management from improperly fleecing the creditors of limited liability companies. So, for instance, if your company is going down the tubes, and so you decide to simply transfer all of the company's assets to yourself, or if you keep running up debts you could not possibly pay, then you can be held liable. In order to be held liable for the above, the company's liquidator needs to be able to prove that the company was insolvent at the time you engaged in the improper conduct, which necessarily requires analyzing the company's financial records. If the company never kept financial records, which is itself a breach of the law, then insolvency is presumed to avoid company directors being able to avoid liability in that way. Now for the loophole, the above presumption only applies if your company did not keep or retain financial records. However, the instant your company is in liquidation, the equivalent of bankruptcy in the USA, a company director ceases to be an agent of the company. So if they take the company's books and destroy them, then the presumption of insolvency does not apply, since it was not the company that destroyed them. You can be prosecuted for the destruction of the company's books, but it's basically a slap on the wrist fine in practice. So long as you can live with that, it means you can get away with virtually any unlawful conduct you engaged in while running the company. The above may not be something that pops up every day, and it may not make for great party conversation, but it is a rather gaping loophole that makes a huge difference to a director's responsibility in Australia. TL Deck, if you are a company director in Australia and you improperly looted your insolvent company, you can get away with it if you destroy the company's financial records after the company goes into bankruptcy. Before we continue, do us a quick favor, smash that like button and subscribe to support our channel. Story 2. If a working girl are your persuasion, a neat trick to see if said worker is a cop is to start with paid unclothed modeling. A worker will always do it because it's easy money. A cop will turn you down because it wastes their time. Make sure they are clear at the beginning that you are only interested in unclothed modeling. Don't suggest that anything else might be of interest. Once the photos are procured, it should be safe to move on to other stuff. Story 3. In terms of loopholes, my criminal law professor was also a practicing criminal defense barrister, and he told this story about a case he had won. The event happened in the city of Jervis Bay in Australia, which is notable because it's an annexed part of federal land so that our capital territory can have an active port. My professor's client had gotten into a fight on the beach, and in knee-deep water proceeded to beat the crap out of the guy he was fighting. Assault charges were laid, and it went to court. My professor managed to find that, at the time, the delineation of the federal land around Jervis Bay ended at the high water mark. Also, at that time, the delineation of the coastal region belonging to the state ended at the low water mark. He managed to show that, because the crime had happened in between these 2 points, neither the state or federal court had jurisdiction to try the client, and he got off. Obviously, the definitions were amended after that so that there would not be such a gap, but that one guy got through. Story 4. All right, so I'm a lawyer, and this one story always sticks with me because of how bizarre and unexpected it was. A few years ago, I was handling a case for a small business owner who ran a pretty popular coffee shop. She had a really loyal customer base, but one of her competitors, a larger chain, tried to push her out by buying up the property next door and putting in a giant sign that basically overshadowed hers. They even used the same exact colors in the logo, so it was like they were copying her brand. Now the interesting part, when we started looking into potential legal avenues, we found a local ordinance from the 1950s. It was a really obscure zoning law that said businesses in this specific area could not have signage larger than a certain size unless they were a certain distance from the highway. The catch? This law was never enforced, ever, but it was still technically on the books. So after some digging, we realized the big chain was technically violating that law because they were using a massive highway-facing sign that was much bigger than the code allowed. It was an outdated regulation that no one had thought to check on for decades. But with a little legal maneuvering, we were able to use this random loophole to make a case against them. The chain tried to argue it wasn't relevant anymore since it hadn't been enforced for so long. But the thing is, laws don't just disappear because they've been ignored. The judge ruled in our favor, and the big chain had to take down the sign, relocate it, and pay a fine. It wasn't a massive victory, but for a small business owner facing this corporate giant, it felt pretty sweet to use an obscure law from the 50s to defend her business. It made me realize how important it is to always check the fine print, and to be aware of laws that might seem irrelevant, but could actually pack a punch if you know where to look. Anyone else got some wild legal loophole stories? Would love to hear them. Story 5. Not a lawyer, but I do work as a repossession agent. If you have knowledge that the loan company is coming to repossess your car, parking it on the neighbor's property will most likely not allow us to proceed. Contracts don't allow us to repossess from different addresses on the warrant. Cars parked at the neighbor's, we can't touch it. Story 6. Nefer, Michigan, if a sues B and secures a judgment for money damages, these are the rules on what B can keep. All family pictures, all arms and accoutrements required by law to be kept by any person, all wearing apparel of every person or family, and provisions and fuel for comfortable subsistence of each householder and his or her family for 6 months. All household goods, furniture, utensils, books, and appliances not exceeding in value $1,000. Seat, pew, or slip occupied by the judgment debtor or the judgment debtor's family in any house or place of public worship, and all cemeteries, tombs, and rites of burial while in use as repositories of the dead of the judgment debtor's family or kept for burial of the judgment debtor, due to each householder 10 sheep, 2 cows, 5 swine, 100 hens, 5 roosters, and a sufficient quantity of hay and grain, growing or otherwise, for properly keeping the animals and poultry for 6 months. The tools, implements, materials, stock, apparatus, team, vehicle, motor vehicle, horses, harness, or other things to enable a person to carry on the profession, trade, occupation, or business in which the person is principally engaged, not exceeding in value $1,000. Story 7. I regularly tell people there is no magic number on a DUI charge. While there is a legal DUI limit, .08 in the states, above which you are automatically considered impaired, so long as the reading is considered valid and admissible, most states have laws which allow any amount of alcohol in your system to qualify for the charge if the state can show the amount, no matter how low, sufficiently impaired your ability to operate the vehicle. Here we have DUI, driving under the influence, and DUI, driving while intoxicated, as basically separate laws. The first requires a .08. The second requires a showing you were intoxicated to a point your ability was sufficiently lessened. Fun fact to throw out at the local bar when someone starts talking about how they had 3 beers and are below the legal limit, and therefore won't get a DUI as a result. Story 8. I work at a petrol station in the UK. If you fill up your car and walk into the shop without a suitable means of pay, forgot your cash card doesn't work, we will give you an IOU form and you are not legally required to come back and pay the balance. We can send you a maximum of 3 letters and that's it. It would cost us more for court costs, etc. to get the cash off you. Sorry, I am not pertaining to ops lawyer answers, but I thought you would find this useful. Story 9. I read in a book once that there is an outdated law in Alberta that hasn't been changed. This was a few years back though, that if you are released from jail you can demand a loaded gun and a horse to ride out of town. Anybody know what happened to this one? Comment. I can see this now. I demand a gun and horse. Cops happily provide gun and horse. Do you have a license for that gun and horse? No. Cops take gun and horse and throw you in jail. Story 10. Okay, this one is a bit wild, and it happened during my first year practicing law. I had a client who was an up-and-coming restaurant owner, and she was dealing with a very strange situation involving a competitor. This competitor had a great location across the street from her, but their business was struggling. So what did they do? They started targeting my client's customers directly. They sent out flyers with very misleading information, claiming my client's restaurant was unsafe, had food violations, and basically made up a bunch of stuff that could have really harmed her reputation. It was clear they were trying to put her out of business, But here's where it gets interesting. In my research, I found something in the local defamation laws that I'd never seen before. If a false claim is made with the intent to harm someone's business, the victim could not only sue for damages, but they could also request a court order to stop any future false claims and seize any profits made from those false claims. Now here's the kicker. The law had a clause that said seizing profits applied to both the defendant's revenue from the false claims and their competitor's revenue that was lost because of it. Meaning we could potentially claim the revenue my client lost due to the competitor's false advertising if we could prove it was directly caused by the false claims. We didn't just have to prove the defamation, we had to show it caused financial harm. This is where the real fun began. We set up a secret shopper program where we had people ask the competitor about my client's restaurant and see if they pushed the false narrative. We got enough evidence showing that this competitor wasn't just making false claims, they were actively feeding this misinformation to customers to divert them to their place. Long story short, after some back and forth, the judge ruled in favor of my client and allowed us to pursue not just damages, but also a claim for the profits the competitor made from the false narrative. We didn't get the entire revenue, but we got a lot of it. The competitor had to pay up big time, and my client ended up winning both a financial battle and a reputational victory. It was a strange and unexpected loophole in defamation law that I didn't even know existed until I started researching it. Who knew you could take a competitor's profits from false advertising? The takeaway here is that there's always a law or loophole that can turn the tide in a case. You just have to know where to look. Story 11. Best practical advice. If you get a DUI, refuse the breathalyzer. Always refuse it. Regardless of state laws, there's no upside. You can fight the mandatory license suspension at an admin level, and if they get a reading, you are going to have a really hard time beating the charge. Also, a prosecutor I used to work with said, if you want to get away with a serious crime, it's easy. 1. Don't tell anyone. Most important, 90% of serious crimes are admitted to someone, most often the police. 2. Don't use your cell phone in or around the crime. 3. Don't talk to the police lawyer up. See Rule 1 if you become a person of interest. It's really hard to prosecute with no admission, no cell phone records. Eyewitness testimony is not enough typically. Can't use DNA evidence without circumstantial evidence. Story 12. 544B of the Bankruptcy Code allows the trustee, basically a person appointed to look out for creditors in a bankruptcy case, to assert the rights that actual creditors could assert in order to bring property into the estate. For example, let's say that you regularly lend money to a dry goods store. In return, you take a lien on their assets. One day you walk towards the dry goods store and you are happy. The sun is shining and bluebirds are chirping in the branches of joyous trees. But when you enter the store, your face falls. The inventory is there, but the owner is nowhere to be seen. You speak with the man behind the counter, and he tells you that the old owner sold him the store and its inventory, lock, stock, and barrel. He has skipped town. Later on, you learn that he has filed for bankruptcy, and naturally, you would like to get your money back. So you'd like to slap a lien on the inventory of the store and then sell it off and get your cheddar. You can do this under non-bankruptcy law because you are in a jurisdiction where the applicable bulk sale laws state that the seller's obligations to you follow the inventory he has sold. You are happy to learn that 544B of the Bankruptcy Code allows the trustee in bankruptcy to assert the same right to the goods. The other creditors are overjoyed to learn that they have received a windfall. As it turns out, the goods have appreciated in value, such that they were worth substantially more than your loan. However, due to a Supreme Court case called Mortgage Bay, the balance of the loan will be split with the other creditors proportionately, even though under non-bankruptcy law, only you could assert the claim against the goods, and you'd only receive compensation to the extent of your interest. The other creditors are actually ecstatic to hear about you because they realize that that person you made a loan to was actually a corporation. Recently, this corporation reorganized using a leveraged buyout. Essentially, the corporation took out a loan from a bank and used the proceeds to buy its own stock. Because this was a transfer not for reasonable value, and because it rendered the company insolvent, this was a fraudulent conveyance that can be avoided under the Bankruptcy Code Section 548. Because the trustee can use you to assert this claim under 544, the other creditors can now collect the amount of the transfer from the bank, neatly sidestepping the problem of trying to collect from an insolvent debtor. And all because you decided to loan out some dough for dry goods. Story 13. First, there is no such thing as a loophole. Either something is legal or it isn't. The term loophole is used to explain the law of unintended consequences when someone does something legally, taking advantage of a law when it was not necessarily intended for the particular circumstances. Second, consider this from one of the few attorneys I do respect. There are no laws, there are only interpretations of laws and case precedent. This applies too to our Constitution, a loosely worded document which regularly gets cited by citizens as in that's not constitutional. Okay, as recently as Tuesday I thought this was an interesting loophole in open primary states. Like here in Georgia, you don't have to declare whether you are a Democrat or Republican to vote in a primary of either, although if both have primaries you can only vote in one. So this year in open primary states, there are a lot of Democrats who are voting for the Republican who they believe will have the lesser chance of beating President Obama. The open primary reasoning is that one shouldn't have to decide until the general election whether they'll vote Democrat or Republican. But the loophole means voters can vote an anti-vote. Story 14. So this happened about 3 years ago when I was a young associate at a mid-sized firm. We were working on a contract dispute case where two small companies had entered into an agreement to collaborate on a product line. The terms seemed straightforward at first, but as we started digging into the contract, we realized there was a very strange clause tucked away in the fine print. It wasn't an obvious loophole, but more like a legal trapdoor. The clause said that in the event of a dispute, instead of going to court or even mediation, the two parties would have to submit to arbitration by an independent professional of mutual agreement. That seemed normal enough, right? Arbitration clauses are pretty common, but here's where it gets wild. The clause also stated that if the parties couldn't agree on an independent arbitrator, then the parties would go to the local pizza parlor, and the owner would choose the arbitrator. Yeah, you read that right, a pizza parlor. The logic, as explained by the contract's drafters, was that it was a neutral, non-legal space that was impartial, and the pizza parlor owner would be able to choose a neutral arbitrator to settle any disputes. I remember thinking, is this a joke? I checked the language again, and sure enough, it was there in black and white. If the two companies couldn't agree on an arbitrator, the pizza guy would choose one. But here's the kicker. There was absolutely no mention of what would happen if the pizza parlor owner wasn't available or didn't want to participate in the arbitration process. Was the agreement then void? Did they have to choose another pizza parlor? The whole thing was completely bizarre. After talking to the other side's lawyer, we realized that they had been operating under the assumption that this was some sort of silly formality, and that if the dispute ever went to arbitration, the pizza parlor owner would just pick someone from their social circle. But we couldn't let it slide. We took the unusual route of actually meeting with the pizza parlor owner to see if he was indeed neutral enough to appoint an arbitrator. The guy was super nice, but he had no background in law whatsoever. He was just a small business owner who apparently had the power to resolve multi-million-dollar disputes. In fact, he hadn't even read the contract before. In the end, we argued that the clause was so vague and unreasonable that it essentially rendered the contract unenforceable. The court agreed and ruled that the clause was unconscionable, meaning it was one-sided and heavily skewed in favor of one party without any clear enforceable terms. What started as a goofy oversight by the drafting party turned into a major win for my client. The company got out of the contract without penalty, and the whole thing became a legal lesson for me in reading the fine print and the absurdity that can sometimes come with contracts. So, moral of the story, always read the fine print and make sure you have some real terms in your contracts, not just something that sounds like it was made up on a whim. Story 15. If you live in an oil-producing state, odds are you don't own the rights to the oil under your land. However, the person who does own the oil rights is fully entitled to come on your land, set up a drilling rig, lay pipelines, install storage tanks, build a frack water pond, and do basically anything needed to get the oil out of the ground. They don't need your permission to do this. It is not trespassing, and there is virtually nothing you can do to stop them. Story 16. I think that the requirement our president is born in the USA is interesting as it is very outdated, as is the 35 years of age requirement. The born here requirement was put in our Constitution for fear of a president still being loyal to the King of England. What are we afraid of today? I use the Arnold Schwarzenegger example. Regardless of what you think of his politics or family values, nobody can question his patriotism. What are we afraid of? That we'll all become subjects of Austria and be forced to learn to ski. Same goes for the age requirement. If voters want to elect a 29-year-old who was born elsewhere, should that not be a decision left to the voters? P.S. It's often stated that a non-born here cannot be a candidate for the presidency. This is not true. She could just not assume office. I'm registered with the FEC as a presidential candidate, and I was never asked to prove my birthplace nor age. Story 17. The fruit of the poisonous tree doctrine. Essentially, if the state conducts an illegal search, any subsequent fruit of the illegal search is inadmissible. Best example is Wong Sun Vive, United States. Government did illegal search of A and incriminated B. Police went to B and found drugs. B then incriminated C, the supplier. Police went to C. C invited police in to discuss. C then went to the station and made a voluntary confession. Supreme Court found that A and B were protected by Fourth Amendment exclusionary rule. C would have been had he not gone to police station to voluntarily confess. If this seems confusing, read the case for more confusion. Story 18. In Denmark, if the sea between Sweden and Denmark freezes and a Swede crosses the ice on foot, you're allowed to beat him/her with a stick until they leave. Best part, it's in our Constitution, so it's nearly impossible to change it. Edit. Shims pointed out in a reply that it's not our Constitution, but just the Danish law. I did some quick searching around and couldn't find a proper source, but I found the explanation for the law. The sea between Denmark and Sweden, Resund froze solid enough for the Swedish army to cross. We've always been fighting, check our history. It's not pretty, and it ended up with Denmark losing a lot of territory. According to everything I can find on the internet, this was what led the Danish king to make this law. Story 19. Someone you're married to can't testify against you about something you told them even if they wanted to, so feel free to tell your spouse about that time you did something illegal. However, someone you're married to can choose whether or not they want to testify against you about something they actually saw you doing, so only let your spouse watch you do something illegal if you really trust them. Edit. Calm down, kids. That was a 4 a.m. alien blue post. Most laws' rules vary depending on jurisdiction. It is a general rule. Source IAAL. Also, sorry if I ruined TV for you. I assure you it was neither my intent or my source. And anyway, I'm only on season 2 of Breaking Bad, so thanks for spoiling that for me. We're even now. Edit 2 California Evidence Code and Plain English Wikipedia. Depending on whether it's civil or criminal, and what the crime is, generally the spouse can't be forced to testify. In some cases, the person who is being testified against can prevent testimony. Sometimes it is up to the spouse who would be testifying. Edit 3. I guarantee I've watched more Law and Order than you. Stop citing it. Hearsay doesn't apply to anything someone being sued, tried for a crime says. It's a party admission, like a confession, for example. You think when Benson testifies that the rapist confessed to the crime, the defense attorney can yell, "Objection, hearsay," and have the testimony thrown out. However, communication by the party can still be privileged, such as attorney-client privilege, spousal privilege, doctors and priests. Law is complicated. That's why lawyers are often pedantic and terrible. Story 20. This one happened a few years ago when I was working in intellectual property law. I had a client, a small but successful online retailer, who came to us with a very unusual problem. They were selling a popular brand of novelty socks, which had cartoon characters on them, and a competitor started selling knockoff socks with nearly identical designs. At first it seemed like a clear-cut case of trademark infringement, but there was a twist. The competitor's socks didn't have the cartoon characters exactly. They had slightly altered the designs, just enough so that they weren't an exact copy. The characters still looked similar, but not identical. It was like they had swapped one color for another, or changed the shape of the eyes by just a little bit, and on top of that, The competitor's socks didn't use the exact same name or branding, so it wasn't clear if they were infringing on the trademark or not. We were up against a serious legal conundrum because it wasn't a direct copy, it was more of a look-alike situation. After some back and forth, we started digging deeper into this case, and that's when we found a very interesting loophole in trademark law. There's a concept in trademark infringement cases called the likelihood of confusion test, where the courts look at whether an average consumer would be confused about the source of the goods. We discovered that if a company's SEP's brand has a strong and recognizable market presence like, say, Disney or Marvel, even minor similarities could lead to consumer confusion, even if the exact details weren't SEP's copied. But here's SEP's where things got wild. While researching case law, I came across an older, obscure case where the court ruled that slight variations in design weren't enough to prove infringement unless the plaintiff could show actual consumer confusion. In other words, if our client couldn't show that people were actually confused between the two socks, we might not have a case. Just because the designs looked similar wasn't enough. Actual confusion had to be demonstrated. To get around this, we sent out a small survey to our clients' customers. We asked them if they had seen the competitor's socks and if they thought they were from the same company. The results were fascinating. Almost 60% of respondents thought the knockoff socks were from the same brand. So we went back to court with this survey data, arguing that the likelihood of confusion was so high that it didn't matter how small the differences in the design were. The competitor tried to counter with the argument that the designs weren't identical, and therefore no infringement occurred, but we had the survey evidence on our side. The judge sided with us, agreeing that the consumer confusion was enough to justify a ruling in our favor. It was a huge win for our client, and it all came down to a small loophole that existed in the way courts interpret trademark law. The moral of the story: if you can't prove infringement directly, sometimes you can prove it through consumer confusion. And make sure you get creative with your evidence gathering. You never know when a simple survey can be the key to winning a case. Story 21. Not a lawyer, but if you want to write someone out of your will, especially a child or spouse, it can be tricky because they can challenge the will and often win and cause a big expensive headache for everybody involved. Here's a loophole. Put a clause in the will that gives the person some paltry sum on the condition that they don't challenge the will. So little Jimmy, who has constantly disappointed you, has to make the choice between $5,000 right now or the possibility of spending a lot on a lawyer and not getting anything. Story 22. In Tasmania, Australia's Alaska, the age of consent for intimate times, specifically penetration to the least degree of the V.A. or mouth with a male genital, is 17, unless you're both over 15 and the age gap is less than 5 years, or you're both over 12 and the age gap is less than 2 years. This applies to everything except backdoor intimacy, for which you must be over 17, even if you're pitching. Also, there's a defense. If you honestly and reasonably believe the other party to be over 17 and they're not, but not for the age gap stuff. So if you honestly and reasonably believe them to be 16 and you're 17 and a half, but they're actually just over 15, you're going to jail. Yes, I know a lot about sexual consent laws. What of it? Story 23. I'm not a lawyer but a paralegal in various capacities. You can pretty much claim anything as a work-related injury. If you get carpal tunnel, for example, you can also say that your carpal tunnel causes you depression, anxiety, and insomnia. If they're not disputing the carpal tunnel, they probably won't dispute anything else you add on. If they want to dispute it, they will have to pay for the doctor to prove you don't have depression/anxiety/insomnia, and they would rather just give you the money as part of your settlement. Also, wills and trusts are pretty fun. You can pretty much do whatever you want. It's like creating a little fantasy world for after you die, and everyone will be obligated to honor your wishes the best they can. Story 24. Back in my days of habitually roaming the streets intoxicated, I was arrested under CA Penal Code 647, a couple times the law against public drunkenness. Being the functional drunk that I was, I took the time to look into the law and learned that to be arrested under 647 requires more than just being intoxicated. It also specifies that you must be either unable to care for yourself or be blocking public access like a sidewalk or a freeway. They dropped my case both times before going too far, but I was prepared to go to court over it. Another one is Penal Code 314, the law against public nudity. This law specifically states that the nudity must be sexual in nature. So while the public may not like it, you can technically walk around unclothed as long as you aren't being sexual about it. I was arrested for 647-314 one night, and they sent my case to some youth diversion program. I went in and brought a folder full of relevant case law that strengthened the interpretation that nudity is legal as long as it's non-sexual, and presented it to this panel of community leaders, police officers, and law students. Never forgot my closing line. So, as you can see, ma'am, while the display of my anus may be juvenile and crass, I'm clearly not guilty of the offense outlined under 314 PC. They told me that this wasn't a court, and therefore case law was irrelevant. The fact that the community members could be offended made me guilty. I told them that was a perversion of justice and to send the case to trial. Never heard back, most likely because it wouldn't be worth anyone's time to try and prosecute rather than because of my half-full lawyer skills. Story 25. If you own a company, don't pay yourself as an employee. Instead, set it up as a corporation and pay yourself dividends. You pay way less in taxes. Dividends are taxed as ordinary income rates to the individual yourself, so no gain there. You might be confused with capital gains, which can work too if you keep reinvesting money in the business and only cash out later in the form of selling your company shares at a profit. But you can pay yourself a reasonable, IRS uses guidelines, salary, and if it's below the current $106,500 ceiling for FICA taxes, you won't be paying the full FICA on what you are earning. For example, if you pay yourself $66,500, you then pay FICA and income taxes on the $66,500. You can then take $50,000 in profits as a dividend and pay only income taxes on the $50,000 with no FICA. This would be 15.3%, since it's both your share and the company's share. The downside is you are putting less into your Social Security for your own old age. So in effect, you earn $106,500, but only pay FICA on the $66,500. This discussion is based on a corporation who declares subchapters for tax purposes. If you are a C corporation, it's different ballgame. Story 26. This one is from my time working as a corporate lawyer, and it's a bit of a wild ride. I was handling a case for a well-established tech company that had just launched a new product, a smart home device. The product was frankly pretty innovative, and we were expecting a lot of hype around it. However, a few months after the product launched, we got a letter from a competitor accusing our client of patent infringement. At first glance, it seemed pretty serious. The competitor had a patent for a slightly similar technology, but the patent was so broad that it could have covered almost any smart home device that connected to the internet. The competitor's lawyers were demanding that we cease production of our client's product immediately or face legal action. So we went into defense mode, prepping for what we thought was going to be a huge battle. But here's where the loophole came into play. As we were reviewing the patent, we stumbled upon something very odd in the documentation. It wasn't the usual case of, oops, the competitor doesn't have a leg to stand on. No, it was something much stranger. It turned out that the patent they were asserting had a weird flaw. The competitor's patent described a very specific technology, but they'd made a critical mistake when they filed. The patent was filed with an incorrect priority date, meaning the date they had used to file their patent application was wrong. It was a minor detail, but it was a fatal one. The priority date was critical because if their invention was already publicly disclosed before the priority date, their patent would be invalid. And guess what? We found evidence that the technology the competitor was claiming to have invented had already been publicly discussed in tech circles before their priority date. It was a small blog post from a niche tech website, but it was enough to invalidate their patent. The best part? The patent office had missed it when they reviewed the patent, meaning the competitor's patent was still active. It was a golden opportunity. The moment we found that out, we had the grounds to not only dismiss their claim of infringement, but also to invalidate their entire patent. Instead of fighting them on the infringement claims, we turned the tables and filed for a patent review. We argued that the competitor's patent should be revoked based on prior public disclosure. The competitor's lawyers fought back, of course, But once the patent office reviewed the case and saw the blog post, they had no choice but to cancel the patent. In the end, not only did we get our client out of a potentially costly lawsuit, but we also rendered the competitor's entire patent portfolio meaningless. It was a huge win, and it all hinged on a tiny mistake in a patent application, a mistake that even the most experienced lawyers didn't catch at first. This case showed me that in the world of intellectual property law, sometimes the smallest detail can make the biggest difference. So for anyone reading this, always double-check priority dates in patents. It's easy to miss, but in my case, it was the loophole that saved our client from an expensive and drawn-out legal battle. Story 27. This should be at the top of the page. You can never waive gross negligence. All those half-retarded waivers you signed before going skiing or rock climbing or whatever are basically toilet paper. If you're seriously injured because they screwed up, call Saul. You can rub their nose in the contract you wiped your bottom with waiving such a thing before your accident. For California residents, if you write a bad review of a business on Yelp or whatever, and they sue you for defamation, you can anti-SLAPP, anti-strategic lawsuit against public participation. They must prove everything immediately without discovery. You should basically feel like Charlie finding the golden ticket, because a good attorney will have you owning their business. They'll pay you, pay your attorney, and you can SLAPP back by countersuing for things like emotional distress. Evil lawyer time. Emo distress is a countersuit because you know a jury listening to the way some company tried to shut you up and impede your free speech will punish the ever-loving hell out of them in a verdict, even if you're mentally okay. And honestly, a suit like that would seriously disrupt your life anyway, so don't feel bad about going for the jugular. / law student, not legal advice. Story 28. When you pay for something with a Visa or MasterCard, if the clerk asks you for your ID, you can simply refuse provided the back of your card is signed. No matter what the clerk, supervisor, or manager say, if they want to continue to accept Visa MasterCard, they must abide by the merchant agreement in place. The merchant agreement specifically states that a signature is all that is required to process the payment, unless the signature doesn't match the back of the card. They cannot force you to produce your ID, no matter what they say about it being their store policy. Also, they cannot impose a minimum amount for you to use your credit card. Merchants do this to avoid the charge they incur for processing the payment, but they are explicitly not allowed to. Story 29. So this is a story from my time working as a criminal defense attorney. It's about an unexpected loophole in a seemingly straightforward case. A client of mine, we'll call him Tom, was charged with a fairly common crime, theft. He was caught on camera stealing a purse from a department store, and there was no real dispute about the fact that he had taken it. It seemed like a pretty open and shut case. The prosecution was confident they'd secure a conviction, and frankly, I was expecting to spend the majority of my time trying to get a lighter sentence for him. But here's where things took an unexpected turn. I started going through the evidence and noticed something odd in the store's security footage. The footage showed Tom walking into the store, looking around a bit, and then taking the purse off a display rack. Pretty typical, right? However, as I continued watching, I noticed the security guard on the video, who was supposed to be monitoring the store, was facing the opposite direction when Tom took the purse. The guard was distracted, talking to a coworker, and had his back turned for a good 30 seconds during the theft. Now that's not the weird part. The weird part was that the store's security policy stated that the guards were required to have a clear line of sight to the front of the store at all times, and there was a clause about requiring the security team to intervene if a theft was occurring in the store. The policy had been established to ensure that if something like this happened, the guard could immediately stop the theft and call the police. In this case, the guard had failed to meet the store's own security policy, and as a result, there was a technicality I could exploit. I dug deeper into the store's records, and sure enough, the security guard had a history of not adhering to the policy. He had been reprimanded multiple times for being distracted and not doing his job properly, and there were several prior incidents where he had been caught slacking off during shifts. The store had even done internal audits after other thefts had happened and found issues with their security operations. Here's where the loophole came in. Because the store failed to properly enforce their own security policy, they were partly responsible for the theft. If the guard had been doing his job, Tom would have been caught before leaving the store with the purse, I argued that the store had contributed to the crime by not adhering to their own procedures, which led to a situation where Tom was able to steal the purse without being stopped. In court, I pushed the argument that the store's negligence and failure to follow its own security protocols could actually be seen as a contributing factor to Tom's actions. The prosecution had no solid rebuttal to this, because legally, the store was expected to act and prevent thefts from happening in the first place. Ultimately, I was able to get the case dismissed on the grounds of lack of evidence of intent. The argument was that Tom wasn't planning the theft from the beginning. He acted in the heat of the moment, and the store's failure to enforce its own security procedures made it easier for him to take the purse. The judge agreed with me, saying that while Tom's actions were still a crime, the store's inability to protect its own merchandise meant that they shared some responsibility for what happened. It wasn't exactly a get-out-of-jail-free card for Tom, but the case was dropped, and he didn't end up with a conviction. It was one of those rare situations where a combination of negligence and policy oversight made for an interesting loophole in the legal system. I'd never thought I'd win a theft case based on store negligence, but it worked out in the end. Thank you for watching. If you enjoyed this video, be sure to give it a thumbs up, subscribe, and hit the bell icon so you never miss an update.